So, good morning, everyone. And
Good morning.
thank you for being here on a Sunday morning. But I'm sure this is going to be a very, very fruitful session for you all because the subject matter is such that there's going to be a huge takeaway for all of us. And as you have been shared with some information also with the flyers, that today's panel discussion is going to be in two sessions. The first part of the session that's happening now would touch upon two very important industries and a third component, that is pharma and IP, entertainment and media, and the most important blending between the two being traditional knowledge and traditional cultural expressions. Now, this is the most distinguishing feature of this panel discussion, where we are going to try to bring that intersection between the three, between pharma and IP, entertainment media, and traditional knowledge and TCE. So, and the second part of the session would look primarily into the intellectual property in the digital age, where we'll be covering aspects of software and IP, artificial intelligence, semiconductor and intellectual property, etc. So, without much ado, let's begin with the session. And may I have the privilege to introduce you to the distinguished panelists for today, Mr. Rohan Rohatgi and Ashok. So let me give a very brief introduction about the panelists. Mr. Rohan Rohatgi is a partner at RSR Legal, which specializes in intellectual property laws, media and entertainment law, sports law, technology, e-commerce, and data protection laws, as well as into general litigation, arbitration, and transaction matters. Mr. Rohatgi has been practicing for over 15 years in India and has handled cases relating to trademark infringement, copyright infringement, design infringement, right to privacy, etc. He also advises clients on prosecution and enforcement of intellectual property rights, as well as certain regulatory issues relating to e-commerce. Over the years, he has attended various domestic and international conferences and delivered talks on intellectual property aspects, educating police officials, university students, as well as corporates about IP law. He has delivered numerous webinars on various topics like artificial intelligence, traditional knowledge, and cultural expressions, trademarks, etc. A very distinct area of practice that Mr. Rohatgi has also been into is the traditional knowledge and cultural expressions. He is, of course, enrolled with the Bar Council of Delhi and is a member of the Delhi High Court Bar Association and International Trademark Association. Welcome, Mr. Rohan.
Thank you so much, Dr. Narayan, and welcome to my co-panelist as well.
And now I would like to introduce Ashok. Ashok GV is a founder, partner of Factum Law, a dispute resolution counsel, where Ashok represents clients in the food and beverage industries, healthcare, pharmaceuticals, aerospace, defense and technology, banking, financial services, and a lot more other areas. His work in the field of intellectual property rights involves not only advising and assisting clients in as far as protecting and commercially exploiting intellectual property, but he also represents in various intellectual property litigations. He has had the distinction of securing several John Doe orders, which, of course, we'll be discussing as a part of the session today, relating to intellectual property, enforcement of trademarks, etc. He has been invited as a speaker at various forums, independent think tanks, observer research foundations, national law schools across the countries, IITs, IIMs, etc. So this is a brief introduction about our second panelist, Ashok. Ashok, welcome to the session.
Thank you, ma'am. And good to see you again, Rohan.
Yeah, and let's get started with the session. I would like to start with the segment of the pharma industry first. And my first question to Ashok would be, if we are looking at the pharma industry, as we see, according to certain reports that we've had, according to one of the IBEF reports also, which says India is the largest generic drug provider in to the world, supplying over about 50% of the global requirements. And according to one of the ENY reports also, the trajectory of growth of this pharma industry seems very promising, where it says pharma industry aspires to reach about something like a milestone of 130 billion by 2030 and about 450 billion by 2047. And this trajectory is definitely propelled by innovation, as far as the pharma industry is concerned, and of course, integration also with the global pharma landscape. Now, this being the scenario, my question to you, Ashok, would be, given this industry landscape, the healthcare, which and healthcare needs as far as the developing nations like India is concerned, and given the dependence on India by other developing nations, in terms of accessing life-saving drugs at affordable costs, how do you think it has impacted the grant of patents in the pharmaceutical sector?
Thank you for the question, Dr. Pratima. I think India's approach to patenting in the field of pharma sector has been about balancing the need to protect innovation on one side, at the same time also ensuring that access to or implementing the mandate of universal healthcare is not affected. And I think the best example for this is the Novartis case that came out of the Supreme Court, where ultimately the court did not see merit in the patent application that was sought to be asserted, and instead came back and held that this is an effort at patent evergreening, and therefore this will not be considered. And curiously enough, one of the things that the court took cognizance of was correspondences that the Indian government had received from various countries from Africa and other developing countries, practically pleading with India not to grant the patent that was asked for in that particular case. So it just tells you that what India does with its IP protection regime for the pharma sector has a cascading effect across the entire population of developing countries in Asia, Africa, and other parts of the globe. And the other example that I can immediately think of is what transpired in Sri Lanka during the time the COVID hit, because there was also a period of economic collapse. And access to critical drugs became quite difficult. And it was India's effort to supply drugs that won us a lot of goodwill with the Sri Lankan people that last even today. So I think it's about balancing the competing interests of ensuring that effort made into R&D is adequately rewarded. But at the same time, it does not result in a kind of situation where access to these drugs becomes more difficult and people have less and less ability to access critical healthcare. And the way I think we do it is, for example, some of the provisions around compulsory licensing. It does tell you that we don't altogether expropriate the patent. We do ensure that there is some kind of protection afforded to the owners of the innovation itself, but at the same time ensure that it's available for the generic drug manufacturers to make available to the people. So I think it's a way to balance these two things, and I don't think it's going to change in the foreseeable future, given the amount of goodwill that India is generating by supplying these generics across the globe.
And how pervasive is the problem of counterfeiting and spurious drugs in this industry?
So one of the other interesting things that I'm given to believe is that India is also a hub for spurious drugs. So as much as we have generics, we also have an equal number of spurious drugs doing the rounds. And especially in the realm of consumer safety, and I distinctly recollect this one medical malpractice case that we were reviewing, where an eye surgery essentially ended up causing blindness. And when the entire surgical procedure was reviewed by an expert, everything was done by the textbook. Absolutely no lapse on the part of the doctor. And it turns out that the gloves that was made available to him in a particular village in Karnataka was actually not belonging to the original brand owner. It was a counterfeit. And the materials used in the gloves essentially had caused the blindness. So there is a equally big problem of spurious drugs in the country, and I think counterfeiting is a big part of the problem. So ensuring that you have a strong functional enforcement mechanism becomes very critical to ensure that we are known for the generics and not for the counterfeits and spurious products.
Right, right, absolutely. My next question is to both panelists, and I would like to start with Rohan. Given the general, I mean, I want both your opinion on this question. So, given the general reluctance to afford patent protection as far as traditional medicines and cures are concerned, has it somewhere provided an unfair advantage as far as the biotech, pharma, and life science industry is concerned? Rohan, may I start with you?
Sure. So I don't know if it's the unfair advantage to them, really, because at least per Indian law, as per our own Patent Act, we talk a lot about 3D, but the 3P is hardly talked about, where a lot of our traditional knowledge, and I don't know if a lot of a lot of our audience will know about this, but one of the reasons for 3P to also come in was there's a huge history. If you would have heard about the cases in the US regarding the neem and the turmeric and the cases in terms of that is also what led to India developing something which has become uh, pioneering in the world, which is the traditional knowledge database, which was developed by the CSIR. And what it helps us with, and not only in India but worldwide, is anybody who is applying for a patent which has ingredients from India's traditional knowledge. A basic example being a lot of the pharma companies would use haldi or turmeric, which is we know has antiseptic properties, as a part of their inventions. And because today majority of the patent offices have access to this TKDL, we've been able to stop or at least challenge a lot of these inventions who are at least the part which deals with our traditional knowledge. So coming back to your main question, I would say it's not really an unfair advantage. I would say probably if you look at it from their angle, it's an unfair disadvantage to them, right? Because they are unable to protect any such inventions which has components of our traditional knowledge. Uh, Rightfully so, and I think uh, 3P has been now, as an inspiration, been taken over by various South American and maybe African countries, uh, where the traditional knowledge is itself is a huge part of their lifestyles as well. So I would say it's not really an unfair advantage, but maybe an unfair disadvantage to the pharma sector because they're unable to capitalize on the components of our traditional knowledge and utilize them in their own inventions.
Just in the interest of the audience, could you just elaborate on the 3Ps?
So, under Section 3P of the Indian Patent Act, anything which has components of traditional knowledge or something which is known to the public, as you know, one of the main criteria of an invention or a patent when you apply is it should not have been known, it should be novel. So 3P hits you directly there because traditional knowledge has existed for centuries and centuries. So 3P basically is what are not three. Section 3 basically deals with what are not inventions or what is not patentable, and 3P particularly deals with traditional knowledge per se, that components of or traditional knowledge itself cannot form part of a patent or an invention.
Thank you. Ashok, what's your opinion on this?
So I think Rohan said it best, right? And I think there's also a lot of merit to saying that traditional knowledge must not be the subject matter of any efforts at IP protection, be it patent or otherwise. But there is also another issue, right? So I do remember that during the time COVID was at its worst, and we did come across, we had a query for going ahead and trying to seek for approvals of a homeopathic intervention for COVID infection. Now, as and when we started reviewing the literature and trying to see what is the best way to get those approvals, what we also realized is that the entire industry that is based on traditional medicine uh, has one particular problem, which is that there are no clearly designed clinical trial protocols. Because of which, to come back with a conclusion that there is safety, there is efficacy, becomes very difficult to establish, especially from the point of view of health and pharma legislation like the Drugs and Cosmetics Act. So I think I do agree with the notion that patenting probably must be discouraged. But at the same time, I think beyond just the database, we also need to work with traditional knowledge systems to bring them up to speed with the requirements of modern regulations and ensure that they're able to kind of upskill themselves to the point where they can compete with, say, the pharma or the life sciences or the biotech industry. So I think there is a need to further empower, further strengthen the skill set to ensure that we're able to establish that these are legitimate and viable medicinal systems. And I think that work is still something that I would probably assume hasn't been done to its full potential.
Okay. Okay. I'd like to just move to the audience. If they have any questions related, very specific to pharma, maybe we can take one or two questions if you do have. Otherwise, we'll move to the next industry, that's the entertainment and media industry. Any questions here from the audience? Or you could also feel free to post your questions on chat. All right. While they would want to consider, any further questions or clarifications, we'll move on to the entertainment and media industry. Again, going by the numbers, going by the statistics, the Indian media and entertainment industry has grown phenomenally. And again, this is expected to be something like another $29-30 billion in about just a few years from now. Earlier, when we looked at the entertainment and media industry, it was primarily, it was the print media, or we had the electronic media, and again, a very small channel of the electronic media that we have had either through televisions or whatsoever. But in the present context of the way we are accessing the entertainment and media industry through its very many forms, through its very many channels, including the OTTs, the digital media, etc., etc. So there has definitely been some kind of a challenge, I'm sure, in terms of this illicit practice of piracy. So my question to you, Ashok, is that with regard to the traditional broadcasting platforms now having to compete with the OTTs, etc., what impact do you think that technology would have in its efforts to mitigate this illicit practice of piracy?
I think this is it's a fairly interesting question for the reason that I still remember the day and age when we used to work with law enforcement to conduct raids in these certain parts of the cities like Hyderabad or Bangalore, only for the purposes of seizing pirated versions of movies, Bollywood and Hollywood. And at some point of time, there were even reports to suggest that this has become a big source of funding for criminal organizations as well. And then overnight, the entire counterfeit CD selling businesses kind of just completely disappeared, at least in Bangalore. And one of the reasons for that was that internet broadband speeds improved. Torrents became a big thing. So nobody had to really go and pay money in some shady corner of Bangalore to buy a movie anymore. It was available for free. Now, this was a win-lose situation, because on one hand, you did knock out an entire segment of pirates in the process. But at the same time, you now had a bigger challenge in the form of piracy sites, which was accessible from anywhere around the world. And at least with traditional piracy proliferators, you could identify them. You could know where they are, you know who they are. But suddenly it's a nameless pirate on the internet. So I think technology has, in that sense, also been fairly challenging in the domain of IP enforcement. But I also then look at one of the main reasons, one of the reasons why people would perhaps look at downloading content of the internet illegally. Sometimes it was just the lack of accessibility. You simply did not find that content in India. But now, thanks to over-the-top platforms, you have a situation where a wide variety of content which is available internationally but not otherwise available in traditional broadcasting platforms is accessible for a very for a very affordable price. So I think at least the lack of accessibility, which was one of the reasons for this kind of demand existing, has to some extent been addressed by the emergence of OTT platforms. And you also now have the benefit of seeing the very same content that you saw abroad, thanks to the fact that OTT, at least as of date, is not subject to the same kind of censorship oversight that traditional broadcasting platforms have been. So I think in that sense, technology has probably created a little less of an incentive for people to go to an illegal content site and try and download things. But that being said, I think, I mean, I've been observing a spate of orders from, say, the Delhi High Court on illegal broadcasting, and it continues to be a pervasive problem, especially through the internet. So I think that problem is only going to increase. And I'll give you another example. We had a situation where we were trying to work with a television channel for conducting a raid on a traditional, a illegal cable broadcasting business. Now, because the cable broadcasting technology has changed so much, you don't need a big, office space with a lot of equipment. Now, the equipment you need is pretty small and portable. So what we observed was that we are not able to figure out where the illegal signal is coming from, right? So I think with the advent of technology, you're going to see these challenges. Law enforcement is yet to catch up. You don't have the level of awareness to figure out how do you zero in on some of these problems and investigate and prosecute. So with that, I think we are going to see some very interesting and unprecedented challenges in terms of IP enforcement. But there is also a lot less incentive, I think, for people to buy illegal content now.
Right. Okay. Okay. Rohan, I have a question for you. Ashok was just mentioning that the Delhi High Court has passed quite a few judgments in the recent times, as in the recent years, especially, some dynamic injunctions as far as restraining these platforms, even beyond the jurisdiction of the court. So have these been able to effectively restrain these platforms and curb this menace of piracy? What's your opinion?
So it's an interesting aspect, because one of the aspects of dynamic injunctions, while they do go beyond the jurisdiction, is in terms of what we call legally like a long arm statute. The other aspect of this is where why did dynamic injunctions really come in? You stop one site, 10 more mirror sites would open up. And how do you really restrain sites? You can say dynamic injunctions were in a way a combination of John Doe orders, where you were basically extending those injunctions to websites which did not even exist as on date, right? You can restrain somebody as on date who is existing in the market, but as soon as you restrain them, they would open up 10 more mirror sites. And these dynamic injunctions basically extended to those mirror sites as well. But I believe one is the legality of it, one is the practicality of it in terms of enforcement. And I think that is where uh, it does become a huge issue, because while through the Ministry of what we call MeitY and the DOT, to a large extent they've been unable, they've been able to restrict those websites from being viewed in India. But how do you really restrain these websites from being viewed in other countries? Uh, so the applicability of that order beyond the jurisdiction of the court does become a practical enforcement issue. So to a large extent, yes, the dynamic injunctions have been to a large extent been able to curb it, but it would be difficult to really stop it in that sense. But just coming back to what Ashok was saying, uh, I feel to a large extent with the advent of OTT platforms, there has been a huge reduction in the usage patterns. Maybe not in terms of the websites going down or the platforms going down, but today it has become much more easier, be it in terms of content or pricing, that these platforms are available to all of us. And I would just want to kind of give a example. A lot of us now use something called Spotify, and I don't know how many have really
Yes.
viewed the series on how really Spotify came out. Spotify was a result of what we knew as Napster and Pirate Bay, which were huge uh, platforms. I would not say websites, but platforms where torrents could really be exchanged between parties. So somewhere, if you see the early 2000s, the big companies were very reluctant to come into the digital space, and today they can't really function without it. So I think that has not curbed piracy to a large extent, but I think reduce it to a large extent.
Okay. Okay. All right. I have another follow-up question. Again, Rohan, this is for you. India has a rich history as far as folklore is concerned and mythology, storytelling. And there's now a trend for the cinema industry to borrow such folklore. How does the law protect the interest of these communities, which have held the rights over such folklore over generations, with the interest of a producer who has invested money, effort, and to take these stories to a global audience?
So, in terms of India at this point of time, we really don't have any statutory law
Yes.
which protects or allows you to enforce such rights. You would still need to go under the traditional IP models to enforce such rights. Unfortunately, and what is interesting, India was one of the proponents during the Bern Convention in the 1980s to add folklore as part of the performers. But if you read the definition of performers under the Copyright Act, there is no specific mention of folklore artists. Whereas India was the one that suggested this addition in the Bern Convention at the international level. So, but as on date, there is nothing in our statutory law where they can go enforce their rights. But I would give a very interesting example of how the production houses and the traditional communities can come together. Is There was a movie by the name Frozen 2, which Disney had come out. Now, Frozen and Frozen 2 is basically folk tales of the Sami people. For those who don't know, Sami people are basically the indigenous people of the Nordic countries. And an official agreement was entered between Disney and the parliaments of the indigenous people of the Sami, in Norway, in Denmark, uh, and it is a publicly available agreement, at least parts of it are, where one Disney said, "We want to work with you. We want you to give your know-how in terms of your storytelling. We do not want to do anything which hurts your culture." So there have been instances where, I mean, Disney now, because if you see, Disney does a lot of these productions which are basically based on, folk tales of different communities around the world. And what Disney is now doing is really, while there is nothing in the law which, tells them you do it, but as a company policy, they are going out, they are meeting these indigenous communities, they are entering into agreements, they're respecting their traditions, and also being given a certain part of the royalties. So it is an interesting development, but as on date, within the Indian jurisdiction, unfortunately, we have no law which would allow a traditional community go and enforce such rights. Uh, we still believe, as per the Indian law, that this is what is in public domain. So anything which is beyond the realm of copyright protection or the term of copyright falls into public domain as per the general notions of copyright law, which is now changing to a large extent. There are discussions going on at WIPO, IGC regarding all of this. Uh, Later this year, they're actually now, nearly 20 years later, sitting down for a diplomatic conference, oh, sorry, on genetic resources and traditional knowledge. So I believe it's a matter of time before which we really see something on the domestic legislations, but there is a movement worldwide in terms of the thought process. We are going away from the general Western concepts of property and recognizing that these communities have rights which have been misused or misappropriated, what is generally called around the world by corporations. So yes, just to conclude on this question, at this point of time, the performers, at least in India, have no such right to enforce.
Okay. Any questions from the audience?
How it comes. Suppose I wanted to use Netflix in from Maldives. So I tried to register myself, and when I wanted to pay the credit cards, it did not accept it. So showing that it is not acceptable because I think this country hasn't tried something. So then what I did it with the same thing, I get it done from India through online through my family. So how it comes means it is then because of this copyright, under copyright it is, or it is something. Definitely it would be, I think, OTT platform. No, it is under copyrights.
So, if I may,
Yes, please.
so Mr. Das, certainly they are governed by copyright laws, and all the IP laws are territorial in nature. So, there are always country restrictions because apart from IP laws, there are various other laws. Because if you're sitting in Maldives and paying in India, let's say in India, something like even the FEMA might come in because you're paying um, through a different channel or through a different country. So there are various restrictions, even financial laws come into financial regulations come into picture. Copyright law would govern what is there on the OTT platform, but these restrictions may be governed by different financial or other national laws. So you're unable to, you'll realize if you're traveling to the US, for example, and you have a Netflix account even from India, as soon as you're in the US, it knows that you're in the US, your location changes. So therefore, you might be able to view a lot of the content which is not available in India, but only available to the US uh, in the US territory. So
Yes.
there are territorial restrictions which are there. For example, I'll give you an example that I've gone through. Things I can view in India, as soon as I travel to the US, I can't view a lot of those content on those platforms because they're restricted in those countries due to various reasons. So therefore, it's a mix of copyright and other regulatory laws which would not allow you to do so.
Yes, actually, I face this problem actually. Even the same thing also, at present time in Papua New Guinea, I wanted to do it for World Cup football online, but I could not do it ultimately. So same thing, it did not allow that to enroll in online to see these things. So this I faced many two times.
So just
But
to add to what Rohan was saying, that see, if it is a football match that you were looking to view, right? So from the point of view of whoever has the right on to broadcast that football match, the first question that arises is, was that particular owner of the broadcasting right having the right to broadcast it in the territory that you were trying to access it from? Okay. Now, if the right given to him did not permit him to broadcast the football match in the territory of Maldives through Netflix or any other OTT platform,
Mm.
it essentially then becomes a copyright issue, right? So, which is that you will not be you essentially do not have the right to view it sitting out of Maldives. Now,
Yeah, no, I think this case was in Papua New Guinea. It is in the last 3 to 4 months back. So Maldives case was Netflix. Papua New Guinea is the for football match. So I think you are correct that it is territorial restrictions, means they cannot allow.
Correct.
Okay. Nagaraju has a question here. He says, sir, how VPN is regulated? How is VPN regulated?
Rohan, you want to take that?
I'll maybe just take it up. You can certainly add on to it. So VPN is since we are sectoral and in terms of IP, VPN is not regulated through IP laws, but it is majorly regulated either through the information technology laws or through various national security laws, because the usage of VPN can also be for a lot of activities which are usually termed as anti-national. So various organizations, the banned organizations, while nowadays I think everybody has access beyond VPN, there are various channels everybody uses, but a lot of these things are banned either through regulatory notifications, and if there is no law in place. But if there is a law in place, it would not really be under the intellectual property domain per se. It would either be under the information technology domain, as I mentioned earlier, or national security laws or considerations, which the relevant departments or government might regulate through notifications.
So, to add to what Rohan was saying, sometimes this could also fall within the domain of the relevant telecom laws as well. So, because there is an element of connectivity here that needs to be addressed, and the other thing is that a lot of times people say, for example, Netflix, they have certain tools to identify when a VPN is being employed to watch content on the platform. So even in the absence of a very specific statutory framework, you could have a situation where the behavior of the user, especially in terms of which IP address seems to be the one featuring, a content platform like Netflix could very well have tools to figure out that somebody is viewing it through VPN and then immediately block access. So the intervention or the regulation of VPN, I think, is twofold. One is policy and regulation, the other is tech. And I think it will require a combination of both to be able to effectively address the problems posed by VPN.
And since this is an IP-specific subject area, we would want to come back to the discussion on, intellectual property-related aspects. And since we have both panelists who are practitioners here in this specific area of IP enforcement, I have a question specific to that. We've had the Commercial Courts Act, which came in the year 2015. And ever since, we've had a lot of IP enforcements that are happening through this particular jurisdiction, through these particular courts. My question to you both, I would like both of you to take this. Has this advent of the Commercial Courts Act made any difference to the subject of IP enforcement as far as these particular sectors are concerned? Ashok, I would like to start with you first, and Rohan, your thoughts as well on the subject.
So I think the answer to this question is very jurisdiction specific. For example, I think the experiences of us in Bangalore could be very different from the experiences of somebody who's practicing in, say, Bombay or Chennai. The first leg of that question, has it really made a difference? I think that then asks the questions, were the conventional civil courts not sufficient? In Bangalore, with my experience, the conventional civil courts were also doing a fairly commendable job in terms of IP enforcement. We really did not have too many troubles in terms of going and seeking. All the John Doe orders that we secured were from the conventional civil courts. So I think to assume or to say that the conventional civil courts perhaps were not well equipped, I think may probably not be right. But if you look at the challenges that the conventional civil courts were having, the number of judges dedicated to IP matters, the speed and expediency of procedures, in terms of just that, I think Commercial Courts Act really made a difference, because for the first time, for all the the expediency that you wanted to achieve in, say, an IP enforcement action, you had a proper statutory framework that you could fall back on and tell the court that, look, we want you to do this quickly, and you don't even have to hesitate because there is a law that mandates, a certain approach and a certain shift in attitude. But that being said, in the initial days of the Commercial Courts Act, what happened was that we had one commercial court for all of Bangalore. Now, what it did was that in one particular case where we were dealing with an instance of trademark disparagement, and I was for the defendant, the procedure under the Code of Civil Procedure is that if I enter appearance, file my written statement, advance the case, file an application to vacate the injunction, within 30 days, my application to vacate the injunction must be heard and disposed of. Right? So there is a time-bound narrative even under the Conventional Code of Civil Procedure, not even under the Commercial Courts Act. Now, because the Commercial Courts Act came in and there was a dedicated commercial court, the matter was before the commercial court. And because there was just one commercial court for the entire city of Bangalore, it took us 18 months, if not more, to finally get an outcome on that application seeking to set aside the injunction. And our client had a very specific requirement that they wanted to play the advertisement in question at a certain segment around a certain event, which was when they could leverage the maximum return on it. But though Commercial Courts Act was supposed to be expeditious, speedy, and whatnot, merely because the only one commercial court was constituted and it was dealing with the entire length and breadth of Bangalore city, it just ensured that the whole process got far more delayed than what it was under the civil court. Right? And even today in Karnataka, you have a lot of places where it's the conventional civil court with an additional charge of being a commercial court. Right? Now, what this does is the judge who's there, there's enough on his plate already, right, as a civil judge. Now, instead of making him an exclusive commercial court, you also tell him that you do everything that a civil court does, partition suits, succession matters, all of it. But in addition to that, you also become a commercial court where the procedures are significantly different in several material regards. You can never expect that efficiency to come out of the so-called commercial court then. So to my mind, I think the act is an enabling, development. Because what it does is it just gives you something to fall back on and say that procedures have to now become a lot more efficient and a lot more expeditious. But the sheer infrastructure that is needed to ensure that the mandate of the Commercial Courts Act is successfully implemented across, right? And not just in the tier 1 cities. For that, what you need is a lot of investment into creating dedicated and exclusive commercial courts, which will do commercial disputes and nothing else. If you're able to achieve that, then I think the Commercial Courts Act on paper will translate into an experience on the ground. But in the absence of that, I think it's just old wine in a new bottle.
And how about Rohan? What has been your experience?
So I think Ashok certainly covered it, and what he mentioned, I think Delhi has been in terms of the Commercial Court Act, been one of the model cities. So my experience in terms of commercial courts within Delhi and outside Delhi is obviously very different, very similar to what Ashok mentioned. But in terms of Delhi, post the advent of the Commercial Court Act in 15, I believe the initial 2-3 years were slightly difficult. But post to the 2018 amendment that came in, so what happened was initially the pecuniary jurisdiction under the Commercial Courts Act was 1 crores and above. So majorly the matters were only going to the high courts. In Delhi, for example, at that point of time, 1 crore was the pecuniary jurisdiction of filing a case in the Delhi High Court, which was eventually at the same time increased to 2 crores. So if you have a claim below 2 crores and above 1 crores, it would go to a district court. But as soon as it goes above 2 crores, it goes to the High Court. Now, in 2018, that 1 crore was brought down to 3 lakh of rupees. And what they also introduced is a mechanism which to a large extent was influenced by the Civil Procedure Code of the UK, is the pre-institution mediation system.
Yeah.
Now, when we talk about the effectiveness, yes, there has been effectiveness certainly to a large extent, at least in Delhi, I would say, which is my main area of practice. But when we talk about certain aspects like the pre-institution mediation. Uh, I would say 99.9% of the matters don't even reach a mediation stage, uh, and they ultimately end up in court. Now, vis-a-vis IP matters, what happens is majority of the times an exemption is sought on various grounds and is usually granted in IP matters because injunction and usually ex parte injunction is what is really the need and of most of the parties. So the a pre-institution mediation would really defeat that. So if you would see the Delhi High Court, you'll be just seeing exemption applications for doing away with the requirement of pre-institution mediation. But in terms of effectiveness, the way it's been structured in Delhi is any district court you go to has minimum 12 to 15 commercial courts. And it is usually at the level of the district judge who is sitting in the commercial courts. So we are now 9 districts in Delhi. So you can imagine we are nearly 100 plus courts, 100 plus commercial courts within the city of Delhi at the district level. At the High Court level, we have a separate commercial bench. And now, post 2021, when IPAB was abolished and all the matters came to the High Court, an IP division was established within the Delhi High Court, which is now also forming part of the Madras High Court and I believe the Calcutta High Court. So there has been effective disposal, but what it has also done is now any matter that you file which has IP related subjects, which could even be a writ petition or an arbitration, let's say you go in a section 9 or a section 11, you will still be before the IP division. Now you have, at this point of time, you have 2 dedicated judges only for hearing IP matters, which were 3 a year back. So what it has done is, while it's become very sectoral specific and you have judges only dealing with IP matters, be it patents, copyrights, trademarks, sorry, but what it has done is it's already overburdened them. Because effectively, a judge can only hear so many matters in a day effectively. So there are pros and cons, but I think what effectively the Commercial Court Act has done is do away with a lot of the liberties you had under CPC, which have been restricted to a certain time. For example, now you can't file a written statement if you don't do it within 120 days maximum. Under the normal civil procedure code, 90 days is the threshold, but you can, even if you file beyond 90 days, it's a discretionary and a directory period which the court can still allow to be overcome. So there are pros and cons, but I think it's been, I would say, largely effective to a large extent.
Okay.
And I think just to add to that point, you also now begin to see when Commercial Courts Act actually works, when you have sufficient number of courts, you have the right kind of infrastructure being provided to them, right? So I think that is the next leg of the work that needs to be done. The first step is, of course, an enabling legislation. But I think the work that really needs to happen afterwards is this, right? How do you create more courts? And even the reduction of specified value from 1 crore to 3 lakhs, what it did was it just increased the number of commercial disputes overnight. Now, is the system equipped to deal with suddenly the large influx of commercial cases? And can we expect the commercial courts to be as effective if anything above 3 lakhs comes before the commercial courts? So I think these are some things that that we won't have any easy answers to begin with, right? Has to be an evolving process, but the need of the hour is to invest in creating that capacity to really implement the noble mandate of the law itself.
Okay. All right. Yeah, just an extension to the subject of IP enforcement. There has been a discussion of something called the John Doe orders. And Ashok, while we were just introducing you to the audience also, there has been a mention that you have, sought quite a few of these John Doe orders. I would like you to help us understand what are John Doe orders, number one. And how effective are they in the practice of intellectual property rights, IP
Sure.
enforcement?
So, John Doe orders, to put it very crudely, is what you seek against the defendant whose details you don't really know of. The infringement is widespread. It's quite there's many people who's trying to infringe on your IP, and you don't know who they are. You don't know where they are. Some of them are fly-by-night operators. Some of them maybe around. So in situations of this nature, rather than trying to gather the evidence of who these people are and then getting an order, you essentially sue an unknown defendant called John Doe, or Rajiv Kumar, I think is what the nomenclature that India uses.
Or it's Ashok Kumar.
Ashok Kumar, sorry, Ashok Kumar. So you have these unknown defendants being called either a John Doe or an Ashok Kumar, and then you get an order of injunction against them. And then as and when you come across somebody who's actually violating your IP rights, you don't have to file a separate suit and get a separate order. The original John Doe order kind of protects you. So I've had two very different experiences with John Doe. One was in the context of a defamation case where my client was somebody in the realm of political life, and it was election ticket season. So any moment now tickets were going to be granted, and just at that time there was suddenly a whole bunch of news clips that started doing the rounds, which were very disparaging to his interests. So we did not know who they were. We did not know how widespread it was. So that was the first John Doe order we got, which was very effective. The moment we got it, we were able to reach across some 20-25 media houses and were able to effectively stop them from broadcasting this. But the next John Doe order was a trademark matter where my client was facing a case of rampant counterfeiting. It was a very popular product. And the counterfeiting was all the way from Kanyakumari in the south to Bihar, Rajasthan, you name it. It was across the country. Right? Now, we got this John Doe order. The problem was that every time an effort was made to enforce the John Doe order, we would realize that the establishment is no longer available. It's just shut shop and disappeared. Right? So the whole sense of being able to practically enforce the John Doe order became quite a question, because the person who's there in Patna at location A is suddenly no longer there. Right? He's moved across borders and is now suddenly in, say, West Bengal, and is able to push his products across. And law enforcement was not agile enough to quickly adapt and move along. And we would have instances when the smallest of difference would be made to the counterfeit product, and the police would come back and tell us that we can't assist you because it's a different product altogether. And I think the Bombay High Court has effectively addressed that about in a judgment a day or two back, saying that if minor changes will not save you from the ambit of the original order. So then it was a process of having to convince the police to say that, look, this is still a violation of the injunction. You need to still help us. So that then became a problem. And then eventually we had the order. The court's next question in Bangalore was that what next? Right? We have to frame issues. We have to go across with the case. And sometimes the challenge was as simple as saying that John Doe's father's name is not mentioned. And that would be a defect that would take a week to cure. Right? So just getting the whole court system in Bangalore to understand what John Doe was, and then say that this is how a John Doe suit has to be carried forward, was in itself a challenge. So it then thought about the need for, there needs to be more training, there needs to be more, and I think it's good to have something specifically introduced in the procedures itself for a John Doe kind of a suit, rather than leaving it to a little open-ended and for case laws to determine. So the John Doe was probably not as effective as we thought it would be for the trademark counterfeiting problem, because whatever existed in terms of a problem prior to the John Doe order existed even afterwards, because enforcement mechanisms, I think, were not as agile and as quick to act. But that being said, I think just the paper publication of the John Doe order in the form of a public caution notice really had a prolific effect, at least in some jurisdiction in the south. Right, so you had overnight the level of counterfeiting kind of reducing. So it was a mixed reaction, but nevertheless, it was an interesting experience to know how certain jurisdictions are not really very sensitized to what a John Doe order is. And I don't think a Delhi court would ever raise a question of who John Doe's father was, but Bangalore courts would raise that as a defect. So I think you have to really play that by the jurisdiction and then see what's the best way to kind of take it forward.
Ashok, just on a lighter note, you can just say John Doe, father of Ashok Kumar.
Excellent, excellent. Anything that you would like to add here, Rohan, in your experience?
Not really. I think Ashok has covered it widely, but we have, I think Delhi High Court is known for being very pro John Doe's, but I believe the only issue that comes in is in the practical enforcement of those orders, really. While we have great orders that have been passed, I believe there was a very specific order which was passed by Justice Patel in the Bombay High Court regarding John Doe orders, where what was happening, you were getting very wide John Doe orders being passed by courts. And what he did was restrict and narrow it down so that when you're coming for a John Doe order, what are the prerequisites that you should establish? Be very specific. Now, for example, you might have a John Doe, and I'm talking in the realm of copyright law, that you might want a website to take down a certain part of their website, not the whole website. So then you need to be very specific with that domain, with the whole issue. So what was happening earlier was I would just go and say the website should be taken down. The court is like, why? Please prove you're right first. Which part of the website? So what Justice Patel's order did was really, create a precedent in terms of what John Doe orders, so what John Doe petitions shall contain and be very specific with for seeking those orders. So I think the jurisprudence has really developed in terms of John Doe orders. And what we were talking about, dynamic injunctions, I believe are just extension of John Doe orders. Uh, they have been effective to a large extent, but I feel they're less effective on the trademark side. They're more effective on the copyright side because usually these orders are sought against. I'll give you an example now. When any movies are coming out nowadays, it's very normal for production houses to approach the court a few weeks in advance, seeking a blanket John Doe that any platform not be allowed to really uh, play pirated versions of that movie, for example. And they would always have the ISPs, the ministry, and DOT. So the mechanism that comes in is you can't go to court for each and everything. So what happens is you keep on adding the John Does to the list, and a mechanism has been developed. So, for example, let's say when you have the Cricket World Cup or the Football World Cup, they would go and take blanket John Does. So yes, now it's also become very event specific as well. That when you have a big event, you would usually go and take a blanket John Doe to get that protection. And it's then easier to enforce at sometimes, and sometimes it's not. So it all depends on the subject matter, really.
Okay, okay. Rohan, I also have a question again relating to the IP enforcement part. Now, given that there are criminal law remedies as far as infringement of copyrights and trademarks are concerned, how easy is it to invoke them? And what are the best practices that you can recommend as far as these enforcements are concerned?
Sure. So, apologies. So for both copyright and trademark, the enforcement mechanisms, when we're talking about criminal remedies, differ slightly. Now, let's say the copyright law, one under copyright, registration is not really mandatory. But the other issue that you face is when you go and register a criminal complaint with the police authorities, the first thing you need to show is what is your right. Do you have a certificate from the Copyright Office? I'll give you an example. We were working with certain publishers, and we would do these raid actions in various cities across the country. In certain cities where police had a brief understanding of copyright law, they would just ask for the work. For example, I say this in this book, and they said, okay, produce the original and maybe give us a copy of the agreement with the author, and that would suffice. But in certain jurisdictions, they will be like, if you don't have a registration, I am not going to really do anything about it. The other problem that you face is the I would say, a confusion between the copyright and trademark law that is faced at various levels. So, in terms of enforcement, copyright enforcement is slightly much more easier. Um, in terms of trademarks, one issue is what we call Section 1154, that I think Ashok would probably understand, and has been a long-standing demand of uh, various organizations that represent IP owners. Is at 1154, and I'll put it out what really it means is when you register a complaint with the police authorities, the law says that they then need to write to the trademark registry, seek an opinion of the registrar, and on that basis only the action can be carried out. Now, the practical difficulties you face here is at times you might receive last minute tips that a certain good is being transported from A to B. Now, it is impossible for this process to take place within that span of time. If I file a complaint and the police sends this to the registrar of trademarks, you are looking at weeks, if not months, for that opinion to come in. And that too also, after rigorous follow-up with the trademark office. So this has no timelines which have been provided in the trademark law. So practically, we face issues in enforcing these provisions. Now, there is another aspect to it is what a lot of people would do if if they have sufficient time would be if you approach a court of law, if you go to the court of the Metropolitan Magistrate, there the uh, the requirement of getting that opinion is not mandatory. But the other problem is for you to go to a metropolitan magistrate again requires time, and a lot of these issues are time sensitive issues. So these are some of the issues that are faced in terms of copyright and trademark law. But in terms of copyright law, it is much more easier to enforce. Once you have a complaint and the police understands the scope, we have had times, Ashok, especially in areas like even Bangalore and in the vicinity of Bangalore, where the police would say, okay, you sit in the station, we are going to conduct the raid and we'll get the culprits with us and the material. So in certain jurisdictions, even in Bombay for that matter, it is very easy because the police, I think now what happens is we also conduct a lot of trainings. So to a large extent, police now has a basic understanding of these laws and the enforcement per se. Uh, there are other issues in terms of manpower and the police being used for so many reasons, and now certain state police stations have created divisions which deal specifically with these matters, but that is only very few in the country. Uh, these are some. This is what the law is, and these are some of the issues that brand owners or copyright holders face. In terms of the best practices, uh, is one best practice is if you're enforcing, let's say, something which is a logo, not really a word, uh, you kind of do away with the trademark issue by also enforcing copyright law, which is practically what most of us do to in the interest of time. Uh, and certainly you require your registration certificate. One thing which is very important to note is the difference between civil and criminal law. You can still enforce a right in the court of law, even if you don't have a trademark registration, which what is known as passing off. However, in criminal law, a statutory recognition or a registration is mandatory. In terms of trademark law, you cannot enforce uh, common law under criminal law jurisdiction. So, a registration and a valid registration at that point of time is something which is very important. Certainly, documentation in terms of, if it's a company, whoever is authorized, you have your basic authorizations and all of that. Also, what is important is that what is usually done in these cases prior to going to the police is we use investigators, and these investigators are the ones who really give us this information. Uh, so a best practice always, subject to the timing issues, is always have a proper investigation carried out, irrespective of it be a civil or a criminal matter, and only the on the basis of that investigation do you proceed further. So one of the best practices I would say is investigate, and only then proceed. We've had cases where we would receive tip-offs, but even after investigating a party for months or years, we would really not find anything. So, if you look at it from a commercial angle for a client, that is not the best thing. So you need to be very, very careful in terms of having the right information before proceeding, because there are cases where, we've had cases where when we went to a site, we found nothing. And even after doing a recce of other places, the residence of the owner, nothing was found. Now, there can be the drawback of this is there could be a retaliatory civil suit, let's say, for damages that could come in. And that has been a case in one of our cases, this happened where the party filed a suit. You can say it's a counterblast to that for damages. And I mean, somebody could even come in and say for defamation, because when you go for a raid action, it is usually the police also goes along with you. And there could be, if you're in a market area, there could be more public. So he or she could say that, I was defamed by doing this if you don't find anything. On the civil side, one enforcement aspect is a lot of times that we do is where we know that for a lot of reasons the police might not be able to act upon it. If we go to a civil court and in an infringement or a passing of action, we seek appointment of a local commissioner, and the local commissioner would basically be the officer of in court, who would then go to the premises along, obviously, with the officials of the company, and also maybe seek police support, and then go and enforce uh, the rights. So these are basically two or three of the mechanisms that are used in civil and criminal remedies. But as I said, the best practice would really be do a proper investigation before acting upon any of these leads.
Right. Okay, thank you. Rohan, you have been in practice, especially in this area of traditional knowledge and cultural expressions. I'd like to take this opportunity to ask you one particular question, not necessarily and completely related to the entertainment media industry, but something related to that again, which is the fashion industry. So we've been seeing of late that one of the major inspirations around the world, as far as this fashion industry is concerned, is that they draw a lot of patterns, from the traditional and indigenous, even tribal communities. And as you very rightly mentioned earlier, most of the countries don't have laws pertaining to protecting these cultural expressions. So, given this scenario, what do you think, or what in your experiences are the best practices that can be followed, in order to prevent these kind of misappropriations?
Thank you, Dr. Pratima. The difference, slightly from what we were discussing earlier, in terms of copyright law,
Yeah.
is when you talk about fashion, for example, there is an overlap between geographical indications and TCs. A lot of the indigenous patents can also be protected as GIs, at least in India, and they have been. And we have had cases where there have been violations, and there are ongoing cases regarding that. And I'll come to an example and actually show how it really went. It's an ongoing case. Worldwide, there have been cases where, very leading fashion houses, uh, even in Mexico. So Mexico has a huge population of indigenous communities as well, and various brands borrowed or uplifted designs and patterns from those local communities without seeking their approval. Now, in various countries where laws have been developed regarding this, uh, there is what is usually known as the three P's. Is what is prior informed consent, PIC, that you always seek consent of the community. Second is that you also acknowledge. I'm sorry, I can't recall the exact word, but you acknowledge their rights, you seek their approval, and also pay them a certain amount of royalty coming out of it. And in certain countries like Mexico, South Africa, Australia is still working on these laws. Uh, they do have rights where they acknowledge, and methods have been created where such inspirations can legally be done as well by taking consent and paying them a certain amount of royalty about this. But in terms of India, geographical indications right now does allow you to register a few of these patents, which has been done by various tribes, and it allows you to enforce the same. I will, if I may, just share a few examples of really how this has been ongoing. Uh, is this visible? So this is some instances in around the world, particularly to the I would say largely the fashion and the apparel sector. Here you would see a shoe which has patterns inspired from the Guna culture of Panama. Now again, while there was no law to really protect the Guna people, however, there was a lot of public backlash, and therefore Nike had to withdraw this from circulation. Something similar here is what you see here is the Inuit people in which is usually in Alaska, found in Alaska or towards Mexico. Now this is a design, if you see on the right, uh, lifted by this certain brand, and again there was no enforcement at that point of time, but again a huge public backlash, which really forced the brand to recall and apologize. This again are blankets which have been inspired from the native people of Lesotho. You would see the patterns here. This is a very interesting case that happened in India. This never went to court, but again, a lot of these cases, because of the lack of uh, statutory laws, uh, usually face a lot of backlash and force these brands to recall. Now, what you see on the left are these slippers that were introduced by Bata, and the prints that you see are basically those of the Worli tribe, which is in Thane, Maharashtra. Now, that has a very cultural significance to the tribe. And imagine putting it on something like slippers is something which is uh, not only against their culture, but a very sensitive issue. Uh, there was a lot of backlash, but as far as I understand, by then they had sold a good number of slippers already. But this is one example in India that did take place. The other example was when I was talking about GI laws, is the Chekaswang tribe in Nagaland has a registered GI for the Chekaswang shawls. This is what you see was a violation at there's a Surajkot Mela that happens very close to Delhi, and a very famous designer, Ritu Berry, on the invitation of a government body, TriFed, uh, had these created. Now this is basically the same design, which is a registered GI of the Chikaswang people. And the difference here is not only is it a registered GI, but there's a certain pattern that women wear it in a certain way and men wear it in a certain way. This is how this is registered with the GI authority. What you see on the left is what men wear, and the right is the version which the women wear. Now, you would note here is these are patterns which are worn by the women, which are actually the shawls which will be worn by the men. So not only is it a violation of the GI law, but also hurting their cultural and religious sentiments to a large extent. This you would see is actually the Chikiswang tribe, how they really wear these shawls. So because of this dispute, the Chikiswang society, they filed a case in the Nagaland court against the designer and the government body a few years back uh, on the grounds of infringement of geographical indications and other grounds. I believe it's an ongoing case. There has been no outcome to it. Uh, but this is a very interesting development. So coming back to your question, yes, there are laws which do protect in the form of a GI. Now, a very interesting aspect that I would like to really cover here is not many people know, and this is slightly outside the ambit of IP, but still connected. Under the Forest Right Act, forest dwellers, which are usually the scheduled tribes, can actually register their community rights, which include intellectual property rights. However, I believe this is an aspect that not many people know about, even the communities don't know about. So there's not been a single registration till date, but there is a provision which does exist in our statute to register what is, and it's a very wide definition. Anything and everything could fall under it. It's not just anything related to food or forest. So there's an interesting way of how they can actually register something and enforce it in the absence of laws, because the word used is the intellectual property rights of forest dwellers, including their cultural expressions. And this is a law, if I'm not mistaken, came out in 2006, the Forest Right Act. So we have had a provision on our statute, on the statutory books, but unfortunately, not many are aware of it, or it has not really been enforced. Uh, just to conclude, there was a very interesting case in the Supreme Court a few years back that you would have heard about, um, which was the Vedanta mining case. And that was the first time the Supreme Court, I am not aware of any other court, recognizing the cultural rights of a local community. And on that basis, the the company did not get the mining license. And while it's an ongoing dispute, but what was really relevant in terms of traditional cultural expressions or cultural expressions was that the first time the Supreme Court of India recognizing the cultural rights of a local tribe in India, which was unheard of. So, yes, there has been certain judicial recognition to this. There are very few interesting cases, while I can't talk about the specifics, but where in the trademark office, there have been certain uh, disputes raised between traditional communities of different countries, which are ongoing. Uh, so it's an interesting time. We have a very advanced negotiation going on in WIPO, and hopefully we would see a diplomatic conference soon and maybe a convention uh, soon. And interestingly, around 2 or 3 years back, Mr. Piyush Goyal, who is the Minister of Commerce, had made a statement in the Lok Sabha that the government of India is working on a law to protect the traditional cultural expressions of the local communities in India. There have been some papers which have been released by the relevant government bodies to who have done this background research. And the one of the main issues that we are facing worldwide, and this has now become a case of Western notions of intellectual property versus the rest of the world, is that this you see for a community, they don't divide this, that this is my patent or this is my copyright or this is my intellectual property. For them, most of the rights arise from their land. Everything is connected to their land. And what is being talked about in various countries and has been done is they have a sui generis legislation which protects any and all rights of these communities, including their intellectual property rights. However, there are countries which have no laws, which you would find usually in the European nations. Interestingly, America has doesn't have laws, but it has. If you go on the USPTO website, it has a native tribal insignia database where you can actually carry out a search to see if any of your proposed trademarks actually fall within the domain of a tribal insignia. So yes, this is where we are at. There are various developments happening, and in terms of coming back to your question, sorry for going into a different path altogether.
This
But
was an interesting space to watch out for. Yeah. Please go ahead.
so just to conclude, I believe we're also short on time now. Uh, there has been a lot of movement in India as well, because what is interesting is in India, the scheduled tribes and are recognized under the constitution. They have a separate schedule, which is the seventh schedule. Uh, and what is interesting is, and I'm just leaving it out there for everyone to think about, is that all these communities are not governed by the laws introduced by the central and the state governments in terms of their culture. Now, if we tomorrow introduce a law to protect or enforce the TCs, are we in violation of the sixth schedule? And how do we extend it to these communities, which are going to be the flag bearers of this whole issue? So it leaves a very important, even a constitutional question, that can we really, without uh, their consent or extension, really enforce these TCs? Because the sixth schedule protects their cultural rights, and uh, the autonomous councils in a lot of these areas have their own regulations regarding these. So I know for a fact that in Nagaland and Mizoram, they have certain laws which protect their traditional medicine rights as well. So it's an interesting space given our constitutional bifurcations as well in terms of the scheduled tribes. So it'll be an interesting space to watch and how this really develops. Thank you.
Excellent. Thank you. That's all I have from my end. I'd like, I mean, maybe we are already at 11, but if there are any quick questions from the audience, I think we can take one or two questions very quickly.
I think, can I?
Yes, Deepak, please.
Yeah. How GI, so as we know that GI tech can be done in two different states, even two different countries. Like today's newspaper, it has come that Tangail Sari, it is Times of India, is today's newspaper, that it is written that they will get a benefit of 20 to 30%. How financially it will help if GI tag is there?
If I may,
Yeah.
so there have been cases, and I'll give you examples. When there was a case of the Rasagulla, there
Yeah.
was a dispute
In
between
Bangladesh.
Calcutta and Orissa, not even Bangladesh,
Yes.
within the country,
Yeah.
the origin of it. Even
Yes.
Basmati, for that matter, when a GI was filed, now Basmati
Mm.
is not only produced in India, But even in Pakistan, basmati is actually it is said, a good quality, even at times from India. There are places in Afghanistan, Iran as well. So you had even the relevant Pakistan organization, implead themselves before at that point of time, the GI registry, and then maybe the IPAB, where the case was that who is the rightful owner. But eventually, for example, there have been cases where you could find the same thing across different states. So the protection would be across all of those. And what you talk about, what is the benefit of it? I'll give you an example. One, the authenticity of the product is very important. Uh, there are various, like for example, Darjeeling tea is a GI. Now, a GI, as it rightly is a geographical indication arising out of a certain geography in the country, right? Now, somebody, let's say from Tamil Nadu, making uh, a tea and labeling it as Darjeeling tea would really be a violation. Why? Because one, it is not coming out of the area of Darjeeling. Two, it has certain recipes and requisites which no other part of the nation will be able to meet. So it is also to confirm the authenticity of the product. The tag also confirms that this product is authentic. It has been certified. The quality is good, amongst a lot of other issues.
Yeah, but this now in the paper it is shown that the party the GI tax, they will get benefit by 20 to 30%. Means whether this product, once it is GI tag is there, whether the price will increase or price cannot be increased because nobody will take up. Because like such as a Tangail study. So this study is Tangail is based in Bangladesh. I mean the village called Bangladesh, and during division of India Bangladesh at that time, the group of people which has shifted from Bangladesh to India in Chabbish Pargona, and they started the creation with the same technology what they have. So both of them have got the GI tag. So now sari and which has been sold in Calcutta, if it is immediately raised by 20 to 30% after getting the GI tag, then I don't think so that nobody will purchase it. Okay, or it will be less. But how they are telling that, okay, I am getting 20 to 30% gain upon that. So if GI tag is given, then whether the production cost will be less or something, I am not able to find it out. Man, how 20 to 30% they will get benefited. Once I get GI tag, shall it by manufacturing cost of this will be reduced or something?
Not really. It does not really in any way impact your cost, but you still have to comply with a certain, because when you file a GI, for example, there are certain requisites that you need to establish on how this product will be certified. And only the people who are the authorized people can manufacture and sell it in the country, right? In terms of the financials, I am not very well aware, so I will not comment on that. But yes, there is a certain benefit in terms of profit if you are a GI tag, because you're not only being sold in India, you're being sold around the world, and it will give you a certain value of being a certified product, an authentic product. So I think that is what really assists you in a certain percentage of profit.
Understood. Because I think today's newspaper, I think in times of IP related things, a lot of things has come. Even in the pharma, I think Hyderabad's become around 40% growth in patent filings. So in Hyderabad itself, and the pharma has become very high. So as Madam told that, Dr. Fatima told that the Indian pharmaceutical industry is one of the top, means in throughout the world. So then Hyderabad itself is 40% growth. Growth nearly. So I think anyway,
Yeah, sorry, Deepak, I had to cut you short.
Yeah,
We have one last question. Richa, you have a question, but we'll have to make it really fast because we have the upcoming panel discussion as well. Richa, please go on.
Yeah, hi. My question relates to patents. And since we are doing very good in patent filing as a society now, so now moving on to the next step, I want to discuss what platforms do we have on patent monetization, what are the ways. I am myself from IIT Delhi, and we have a lot of technologies, and where we are lagging is this sector now. Patent filing is not an issue, nor patent monetization is an issue. So how can we get support in this? What platforms, what awareness can be brought in here?
The Ministry of Information Technology and the Government of India is actually coming out with a fairly elaborate regime of IP rights and support for that. I believe that something is in the offing specifically on what you said, which is on monetization of IP.
Yeah.
So keep your ears tuned to what the central government is doing, because I think in the next 3 to 4 months or maybe more, you might have some schemes coming out on how universities can better monetize their IP. Right. But independent of that, one way to do that is to have a cell within the university dedicated to taking inventions and tech developed in-house to the industry and the market. One example is the Society of Innovation and Development in IISc, which is specifically engaged in this for IISc generated IP. So have a cell, have a proper model for licensing and assignment of IP, have some models for joint collaborations with the industry. That's probably one way to go about with the monetization of IP itself.
Yeah, we do have a TTO office back in our place, but ours is not academic. I'm related to the research and innovation park, which is the startup ecosystem. So it's government is coming up with something related to academics. Will that be applicable to the startup ecosystem, which we have in every academic institute and other places, also incubators?
So for startups, as it is, there are a lot of schemes to help with IP protection, especially registrations. But again, on the subject of what benefits or help the government can extend to startups also, I believe that is part of the same deliberations around helping universities better monetize their IP.
Okay, fine. Thank you.
Great. So thank you very much. Thank you, Ashok and Rohan. It was a fantastic session and lots of learning in the space of pharma and entertainment and media industry, and also a very, very specific segment on the TK and TCE that Rohan very rightly brought about. Thank you so much, and we look forward to more sessions with you. Thank you.
Thank you so much.